Hello, my name's Andrew Milburn. I'm a private client solicitor here at Levi Solicitors. I deal with areas of law including wills and estate planning, probate and estate administration, contentious probate, trusts, lasting powers of attorney and court of protection work, and issues regarding care home fees. I would advise everybody to have a professionally made will. The vast majority of wills are relatively inexpensive, and most clients are quite surprised how straightforward the process is. There are many good reasons to have a will. If you do not have a will, then the law sets out very strict rules on how your estate would be distributed. These are known as the Rules of Intestacy. A lot of people assume that if they are married and they do not have a will, that their whole estate will pass to their surviving spouse. This is not necessarily the case. It will depend on the value of your estate and which other relatives you leave behind. It's therefore possible that children, grandchildren, parents, brothers or sisters, or even nephews and nieces may become entitled to a share of your estate along with your surviving spouse. Unfortunately, this can sometimes mean that your husband or wife would have to sell estate assets in order to pay the other beneficiaries what they were entitled to. If you are in a relationship but you are not legally married or not part of a civil partnership, then if you do not have a will, your partner would not be entitled to inherit any of your estate under the Rules of Intestacy. There is no concept of common law husband or wife under the laws of England and Wales. If you are in a partnership but are not married, it is therefore vital that you make a will in order to leave whatever share of your estate that you think fit to your partner. It's becoming much more common for married couples to have children from previous relationships. This unfortunately is a source of a great number of estate disputes. This is because if the couple haven't carefully planned their estates, it can result in their combined estates passing only to the family of the spouse who dies second. Estate disputes are becoming much more common, and the costs involved can run up into the tens of thousands of pounds. And these costs quite often are paid from the estate funds. If you take some good estate planning advice, you can ensure that your respective children will receive the share of your estates that you would want them to receive, which can reduce the risk of leaving any disputes after your death. A subject that lots of people are concerned about at the moment is the issue of care home fees. Lots of people come to see me asking whether it's possible to protect their assets against being used for any future care that they may require. This is quite a complicated area of law. There are some options available, all of which have their own pros and cons. I would strongly advise anybody wanting to try to protect their assets against care home fees to seek legal advice so that they can then make an informed decision. If you would like any advice with regards to wills or any issues to do with inheritance, please feel free to contact us and we will arrange an initial free, no obligations meeting with one of our solicitors.